Hi, I'm Greg Dell with Dell Disability Lawyers, here with attorney Alexander Palomara, and this week we're talking about some frequently asked questions that we receive, and we have answer questions by our lawyers on our website, and we're going to focus today on Reliance Standard and on disability appeal related questions. So these will be questions related to people who've been denied by Reliance Standard, and what we think and we see are the most common questions. So with Reliance Standard, a lot of people, when they call, they want to know, can I win my Reliance Standard disability appeal? Meaning, do they ever really reverse these denials?
Of course. I mean, I have personally a few hundred people on claim right now, including many Reliance Standard claimants.
Mm-hmm.
You know, yes, just because they deny your claim doesn't mean the decision's correct. And yes, we're going to do a great appeal to put your case in the best light possible, to give you the best chance of getting back on claim. So certainly you have a good chance. I can't say every single case. Every single case is kind of factually dependent or independent of one another. But if we take on your case, we're going to make sure you have the best chance possible of getting back on claim, and we have a good success rate of getting people back on claim with Reliance Standard appeals.
And I like people to know that, because a lot of people think of these claims like health insurance. If you ever get a health insurance denial, even my own family on issues that I've had, whatever it may be, and I'd just be like, you know what? It's not worth fighting because it's a losing battle. It goes on forever. You're not going to get anywhere. But a Reliance Standard disability denial, yeah, we win them all the time. There's a real leg to stand on, but that gets into that they got to be done the right way. And it is a process, and I want to get into why it is a process and what a person should expect. So if I'm someone who's recently been denied, I want to know, what time frame am I looking at before this whole thing can get back to the point where either I'm getting my benefits reinstated if I was getting paid, or I'm going to get paid for the first time because I'm someone sitting at home and I don't have a source of income?
So one thing that people have to first hear is that you cannot rush an appeal. The insurance company would love for you to rush an appeal, because if you rush an appeal, did a bad appeal, they're going to uphold their denial, and then your lawsuit's going to be that much weaker, because once they issue a denial of your appeal, the claim file is closed and no additional information can be submitted to support your claim. So the judge will never see the other medical records that you forgot to send in. So the appeal cannot be rushed. Don't fall into the trap of rushing the appeal, because the ERISA laws only allow for one appeal, and then once your appeal is denied, you have to file a lawsuit. So the first thing you need to do when you get denied a claim is reach out to us. But if you don't reach out to us, you need to order a copy of your claim file, because you need to know what's in there. The insurance company has 30 days to provide you under the ERISA laws a copy of those records. So it takes time to file an appeal, and the answer people are not going to like my answer. An appeal takes at least, on an average, 90 days to get out to the full 180 days. The ERISA laws give you 180 days to file an appeal, but I know your question is how long? What can people expect? Well, maybe the full 180 days to get the appeal out, and then the insurance company has an additional 90 days to give you an answer on your appeal. I mean, they only have 45, but the ERISA laws allow them to take one additional extension of additional 45 days if they give any excuse whatsoever, for the most part. So you have to be mindful that you might be without income for 6 to 9 months sometimes. But don't fall into the trap of rushing an appeal, because it has to be done properly. It really does.
When you go ahead and work on an appeal, the first thing you do is you get a copy of the claim file, and the claim file is the documents, every single document that Reliance Standard used to deny the claim, every single thing they looked at. And so one of the nice things about ERISA is they have to give you full disclosure, and if they don't, then it's as if it didn't exist. You go through this document, it could be a couple hundred pages or it could be 10,000 pages, and you eat it up and you look for specific things in there they relied upon. Eventually you get to the point of what are medical reviews, which I know you talked a lot about in our other videos, and you find out, okay, this is the doctor they relied upon, this is why they denied the claim, and now I'm going to put my strategy in place. Explain what that process is for your strategy moving forward, and why it has to be what I'm calling even a strategy to get to the spot where you're going to put forth the best appeal possible.
So I go through that claim file, and I find that 1 or 2 physician consultant reviews or internal reviews that they're relying upon to deny your claim, and I go over those reviews with a fine-tooth comb. I want to see what that doctor is listing as saying he reviewed this, this, and that. So let's say he lists 10 different medical records. but there's 30 out there. Like, where are the other 30? So I want to know what exactly he reviewed, make sure he had everything given to him. Sometimes the insurance companies only give a partial file to the doctor.
Right.
So I want to point that out. I want to go through so if there's records they didn't review, I want to make sure I get those records into that appeal and point out this doctor did not review this, this, and this should overturn the decision. Or I want to see if the doctor did get everything and reviewed everything, or listed that, or claimed that he reviewed everything or she reviewed everything. I want to go through his or her analysis to figure out what they misconstrued, what they misinterpreted, or what they just flat out lied about. Because what they're known for doing is going through your medical records and pointing out anytime it says the word mild, it's like, oh, they have mild this, or they point out what's not in there. Well, the doctor didn't say this person was suffering from this, this, and this. But you're overlooking the other stuff that the doctor did say. And remember, the medical records are not written to convince some doctor in an ivory tower that this person's disabled. The medical records are written so that your treating provider can treat you. So the next time when they're seeing you the next time, they go, let me get an update. All right, you're suffering from this. So tell me, so they want to update themselves of where you were last time. So you have to point out, you have to look in those reviews and the reports from those independent consultants and find out where they messed up. Because if my client is saying they're disabled, they can't do this, that, and the other, then there has to be holes in the reports of these consultants' reviews, and we have to find those holes. So that's the most important thing. Get a copy of that review, that report from that independent consultant doctors, and find out where the error is in their report, because there has to be an error.
And in terms of your strategy from taking this report, and then I always shape my appeals in the sense, and I tell claimants, especially against Reliance Standard, look, 80% of the work I'm going to do for you is going to happen before I submit that appeal. But we have to put out the most strong evidence that we possibly can when we submit this appeal. I'm going to write it really well for you, but it's all about the evidence, because when we submit, they need to understand, when we submit this appeal, our letter goes in one stack and the appeal person reads that, right? But then they take out all the evidence that we submitted, and that can be all new evidence that they're going to then take, and they're going to take to either their in-house doctor or somebody that they hired. That evidence that we submit has to be put together in such a manner where whoever they give it to, it has to be shaped in such a way that whoever that doctor is that looks at it, there's no way that he or she could look at that and make an opinion to say, this person can work, or this person can do this activity or that activity. It all depends upon what we're trying to prove, because the definition of disability is different in every policy. It could be an own occupation, being unable to do the duties of your own occupation that you're doing at the time you stopped working, or, which we more commonly see, it's unable to do the duties of any gainful occupation, which means anything you have experience, education, or training for, and sometimes it has an income component. So we have to shape the evidence in such a way to what the definition of disability is. And that requires coordinated efforts with their doctors, with vocational experts, with functional capacity experts, maybe with neuropsych experts, maybe doing medical research, maybe getting testimonies from family members, past coworkers, a whole world of tools that we use, and we have to put it together in a quick manner, as quickly as we can, because there's a time constraint, and remember our claimant sitting at home who's not getting money. You put all this stuff together, and we put together amazing packages, what we call appeal packages, and then they're going to take and they're going to get their opinion from their doctor. And then the claim rep at Reliance Standard is going to see everything that Alex submitted that was an incredible appeal, the 2-page report they got from their doctor, and now Reliance Standard needs to make a decision. How does that Reliance Standard claims person make that decision at that point in time?
For the most part, in my experience, they follow whatever their consultant's report says. Which is, it's hard to believe sometimes, because sometimes there's even on the appeal, the consultant's reports can be so misleading that a person with limited knowledge of the medical field should be able to question the results of that report. But for the most part, they're just making the easy decision, the quick decision. If that consultant says the person's disabled, then they're going to say, all right, then let's put him back on claim. But nowadays, under the ERISA laws, they have to provide us a copy of that report before they issue a final denial letter. So what we do is we get that report, and they only send it to us when they're going to uphold the denial. So then we go full throttle at them. We hit everything else. We take that report to all the treating providers. We'll write a response. I'll write a personal response saying, listen, your doctor's overlooking this, this, and this. Like, give me a break here. A reasonable person should not follow this doctor's report, because here's the medical records that say X, Y, and Z. Take this back to your doctor and have him look at this. And if this doctor's going to uphold his prior opinion, then all great. I can't wait to see you guys, you know? But we have, I write something in response, and so does the doctor. I go back to all my treating providers to make sure they respond to it. So it's kind of, I don't know, sometimes I just get, you know, I lose faith in humanity almost when I see some of the reports that the insurance companies don't even question, you know, some of their own independent reports or some of their internal reports as well.
But as much as so, I like the people watching these videos and who are in this position to understand this is what we're up against. We're going to crush it and do a great appeal, and we're going to get all that evidence. And you should win. But if they get some, I don't know, unscrupulous doctors just looking for a reason to dispute something and not pay, that Reliance Standard claims rep are basically just trained to follow that doctor. Now, because of that, we're always thinking next step. Here's how we're positioned to win at the lawsuit level, because at the lawsuit level, we are married and limited to whatever was submitted in that appeal. So if the client does their own appeal and then hires us, and which is fine, we do that all the time, but we can't add anything new. We can only argue the evidence that's there. So it's a reason why you got to understand that this appeal is, in my opinion, more important than hiring a lawyer saying, I'm going to do my own appeal, I'm going to get a lawyer later to do my litigation, because now you basically decided, like, you know as a claimant what the court's going to be looking for and what you think is the best evidence. But there's best evidence that a claimant may know because the claimant knows themselves better than anybody, but there's also evidence in line with the thousands of cases that have been interpreted by judges and how an insurance company is supposed to look at something and how a judge is supposed to look at evidence in relationship to this world of 1,000 lawsuit cases, which we've read most of them, but new ones come out every week as well. So I try to get people into our brains. If they could do it by themselves, it would be wonderful, but it's a huge injustice to them to try to do this on their own because you're just not equipped. And it's like if we came out, it's like if we had a new lawyer or a lawyer who does Social Security or workers' comp or says they're a personal injury lawyer and tries to dabble in this world of doing this disability, you can't, because you haven't done thousands of these cases. You haven't read thousands of disability. You have no idea what's going on at the court level when you try to tackle it at the appeal level, and it's not just writing a letter. And if you do that, yeah, you might get lucky.
Right.
You might get lucky. But 90% of the time, you're not going to get lucky. And not only that, you're then putting yourself in a bad position, because then it's really hard to win these lawsuits if you don't have a good administrative record.
Right. You need to build that record. And once they issue the final denial, the record is closed, so no additional information can ever be submitted. So it has to be done right. There's no ifs, ands, or buts about it. And I see a lot of times that the insurance company, I think they trick the person. They say, oh, you can't hire a lawyer until the lawsuit stage. So they think they have to do the appeal on their own. But you can hire an attorney, or you can hire a representative to help you with the appeal, and you should hire someone with a lot of experience. You know, a lot of the times my clients go, why didn't you include any case law in your appeal? And I go, I did, but you just didn't realize it, because we read all the case law, then I formulate my arguments. I take the language of a court's ruling that's favorable for an insured, and I use that in my appeals. So I don't say, look at this case, but I use the same language that the judge used, from that case, to hopefully the person at the insurance company knows what I'm writing about. They know the case law. Oftentimes they don't, but they should. But that's what I do in my appeals. So I kind of get the case law in there in a roundabout way without them knowing, so that if it comes to a lawsuit, the judge says, well, the case law says this, and in the appeal, that was the actual argument actually made. They're right. They should win this lawsuit. So,
well, thank you for these answers. I want people out there to know that we're regularly available to answer all these questions, whether you want to publicly ask them on our website, and we'll respond right away and share all of these answers for everyone else out there to learn. Or if you'd like to contact Alex or myself privately, we always provide a free consultation, and we're available to represent you no matter where you live in the country.